The Supreme Court just ruled that Trump's biggest trade weapon was illegal all along. And within days, the White House quietly started building a replacement that could be even harder to stop. Most people heard one half of this story. The headline half: Supreme Court blocks tariffs. Big legal defeat. Case closed. But that's not what actually happened. And if you only heard that version, you're missing the part that actually matters. Because the moment that ruling landed, a second plan was already moving behind it. A different legal path. A different set of powers. One that doesn't need the same justification the Supreme Court just rejected, and one that could end up reshaping global trade for years, with almost no public debate about it at all. This is the story nobody fully connected the dots on. Stay to the end, because the last piece of this puzzle changes how you should think about every tariff headline you see from here on. I'm Marcus, and this is the Quiet Report, where we look past the headline, into the parts of the story that actually decide what happens next. Let's slow down and get this right, because most coverage blurred the details. The tariffs in question were imposed using a law called the International Emergency Economic Powers Act, IEEPA for short. That law was originally designed for genuine national emergencies, freezing assets of hostile regimes, blocking transactions with sanctioned countries, that kind of thing. It was never written with the word tariff anywhere in it. The administration's argument was that persistent trade imbalances and fentanyl trafficking constituted a national emergency severe enough to justify sweeping tariffs on nearly every trading partner, under emergency authority that doesn't require congressional approval. The Supreme Court disagreed, not on narrow technical grounds, on a fundamental structural one. The ruling found that the law simply does not grant the president authority to impose blanket tariffs of this scale. Tariff power under the Constitution sits with Congress. When the executive branch wants to bypass that, courts expect an extremely clear and specific delegation of power. The court found no such clarity here. This wasn't a split decision buried in legal footnotes either. It was a decisive rebuke, one of the more consequential limits placed on emergency executive trade power in decades. So on paper, this looks like a clean win for the rule of law, a clear boundary drawn around presidential power, and it is that. But it's also only half the story. Here's the sentence buried in almost every article that deserved to be the headline instead. The ruling didn't touch tariffs. It touched one specific legal tool used to impose them. There's a difference between saying tariffs are illegal and saying this particular method of imposing tariffs is illegal. The court ruled on the second one, and the administration knew exactly which door was still open, because trade lawyers inside the government had been mapping alternative paths for months before the ruling even came down. The tool being lined up next is a completely different law, Section 301 of the Trade Act of 1974. It's been used before, during trade disputes with China years earlier, and it survived legal scrutiny then. Section 301 lets the president impose tariffs specifically against countries found to be engaging in unfair trade practices, following a formal investigation process through the U.S. Trade Representative's office. That's the back door. Not a loophole exactly, and a completely separate legal doorway that was sitting there the entire time, one the Supreme Court's ruling never addressed because it wasn't part of the case in front of it. Here's why this distinction isn't just a legal technicality. It changes the entire trajectory of what happens next. Under the old method, tariffs could be imposed almost overnight, across nearly every country simultaneously, with no investigation period required. That's what made it so powerful, and also exactly why the court found it constitutionally shaky. That kind of unchecked, instant, universal authority is precisely what triggers separation of powers concerns. Section 301 works differently. It requires a formal investigation into a specific country's trade practices before tariffs can be imposed. That takes time, sometimes months. It also tends to be country-specific rather than universal, meaning tariffs under this path are more likely to target specific nations accused of specific violations rather than blanket rates slapped on the entire world at once. On the surface, that might sound like a softening, slower, more targeted, less chaotic, But look closer and a different picture emerges. Because Section 301 has already survived legal challenges in the past, it's a battle-tested tool. Once tariffs are imposed under it, courts have historically been far more reluctant to strike them down, because Congress explicitly wrote this law to hand exactly this kind of authority to the executive branch, unlike IEEPA, where that authority had to be inferred. In other words, the emergency powers method was fast, sweeping, and legally fragile. The trade law method is slower, but potentially far more durable, and much harder for future courts to unwind. That's the trade-off nobody explained clearly. Slower to build, much harder to tear down. There's a specific date sitting at the center of this entire transition, and it's the reason this story has real urgency instead of being a distant legal abstraction, July 24th. That's when the current blanket tariff structure, the one built under the now struck-down emergency authority, is set to formally expire, following the timeline set by the court's ruling. Between now and then, the administration has to decide exactly how the Section 301 replacement gets built, which countries get targeted first, and how fast the investigation-based process can realistically move. This creates a strange window. For a short period, businesses face genuine uncertainty about which tariffs will still apply and which will lapse. Some economists have pointed out that this kind of uncertainty is almost worse for business planning than a stable, even high tariff rate, because companies can't commit to supply chain decisions when the rules might shift dramatically within weeks. Import-heavy industries are watching this date closely. Retailers, manufacturers relying on overseas components, agricultural exporters bracing for retaliation, all of them are essentially operating in a holding pattern until the picture becomes clearer. Let's talk about where the pressure actually lands, because tariffs as a word tends to flatten a much messier reality underneath it. Consumers are arguably the most exposed group in the near term. Economic estimates suggest a majority of tariff costs get passed directly through to retail prices rather than absorbed by importing companies. That means whatever replaces the current system. If tariff levels stay roughly similar under Section 301, the price impact at the checkout counter likely persists regardless of which legal mechanism technically imposed it. Import-dependent small businesses face a different kind of pain: uncertainty itself. Large multinational corporations often have the legal and financial infrastructure to adapt quickly to a shifting tariff landscape, shifting suppliers, absorbing short-term costs, lobbying directly during the Section 301 investigation process. Smaller businesses typically don't have that flexibility, and the slower, more bureaucratic nature of a 301 investigation can leave them in limbo longer. Certain trading partners face a very different calculation. Because Section 301 requires findings of specific unfair practices against specific countries, this shifts trade tension away from a blanket global approach and toward a more targeted one-country-at-a-time confrontation. That could mean some countries currently facing tariffs see relief, while others, depending on how investigations unfold, face even more concentrated pressure than before. And there's a political dimension too. A more targeted, investigation-based tariff approach is, in some ways, harder to campaign against as a single, unified issue. Blanket tariffs on every country makes for a clean political talking point. Targeted tariffs following individual trade investigations against specific countries for specific violations is a much messier, harder story to tell voters, which may itself be part of why this quieter legal pathway attracts far less media attention than the dramatic Supreme Court headline did. This isn't the first time a president has pivoted between legal tools after hitting a judicial wall on trade policy, and looking at that history tells you a lot about what usually happens next. During prior trade disputes with China, tariffs were built almost entirely through Section 301 investigations from the start, specifically because it was viewed as the more legally durable pathway compared to more exotic emergency powers. Those tariffs, once imposed, largely survived subsequent legal and political challenges, including through a change in administration. The tariffs from that earlier trade conflict remained largely intact for years afterward. regardless of which party held the presidency. That's the pattern worth sitting with. Tariffs imposed through this specific legal channel have historically proven remarkably sticky. Once the formal investigation is complete and the tariff is imposed, unwinding it requires a deliberate political choice to reverse course. It doesn't happen automatically, and it doesn't get struck down easily in court the way the emergency powers version just was. So if the pattern holds here, what looks today like a legal setback for the administration may end up producing a more permanent trade policy shift than the original, more dramatic emergency powers version ever could have. Foreign governments aren't waiting around to see how this plays out. Many are already recalibrating. Trade ministries in several major economies have reportedly begun preparing their own responses to a Section 301-based approach, which requires a different kind of diplomatic and legal engagement than responding to a blanket emergency tariff. Because Section 301 investigations formally allow affected countries to present evidence and arguments during the process, some governments are shifting resources toward building formal legal and economic cases to present during those proceedings, essentially preparing to fight this battle inside the administrative process itself, rather than only through retaliatory tariffs or diplomatic pressure. This also opens a door for negotiation that the blanket emergency approach didn't really allow. Since 301 investigations target specific practices, countries have a more concrete path to potentially resolve disputes by changing the specific practices under investigation, offering a face-saving off-ramp that a sweeping, all-country emergency tariff never provided. Whether that leads to genuine trade concessions or simply more sophisticated legal maneuvering by all sides remains to be seen. But the shift from blanket authority to investigation-based authority fundamentally changes the diplomatic chessboard, even if the headline dollar amounts of tariffs end up looking similar. Let's bring this back to something more immediately practical. Markets initially reacted to the Supreme Court ruling with some relief. A defeat for sweeping unilateral tariff power was read by some investors as reducing long-term trade policy risk. But that relief may prove premature if the Section 301 replacement ends up imposing similar tariff levels through a more legally durable channel. In some ways, a slower but harder to reverse tariff regime could represent more long-term certainty for markets than a fast, sweeping, but legally fragile one, even if the near-term transition period creates volatility. For everyday consumers, the practical impact likely comes down to timing more than magnitude. If the administration successfully transitions major tariffs to the Section 301 framework before the July 24th expiration, the price impact you've already been feeling at the store may simply continue with barely a pause. If the transition takes longer than that, there could be a temporary window where certain tariffs lapse before new ones take effect. A brief reprieve. Though economists caution, it would likely be short-lived, given the stated intent to maintain trade pressure through the alternative legal pathway. For anyone with investments tied to import-heavy retail, agriculture, or manufacturing sectors, this transition period is exactly the kind of event worth tracking closely, since sector-specific impacts could diverge significantly. Depending on which countries end up targeted under the new investigations, nobody in Washington wants to answer directly. Here's the uncomfortable question sitting underneath this entire story. Does judicial oversight of executive trade power actually mean anything if there's always another legal doorway sitting one step behind the one that just got closed? Supporters of strong congressional and judicial checks on executive power would argue that this is exactly how the system is supposed to work. Courts police the boundaries of specific delegated authorities, and if the executive branch wants to keep pursuing similar policy goals, it has to work within a different, more constrained legal framework that Congress explicitly authorized. That's not evasion. That's the separation of powers functioning as designed, forcing policy into channels with more built-in checks, like formal investigations and evidence requirements. Critics see it differently. They'd argue that if the practical outcome, similar tariff levels, similar economic impact, ends up nearly identical regardless of which legal tool gets used, then the judicial check accomplished little beyond forcing a procedural delay and a change in paperwork without meaningfully restraining the underlying policy. Both readings have some truth to them, and reasonable people land in different places here depending on how much weight they put on process versus outcome. That's genuinely one of the more interesting structural questions in American governance right now, and it's playing out in real time through this exact tariff transition. If you want to track this story intelligently, instead of just reacting to the next headline, here are the specific signals worth watching. Watch for the formal announcement of which countries become the first targets of new Section 301 investigations. That will tell you a lot about the administration's actual priorities once it's forced to be more targeted rather than universal. Watch the July 24th deadline itself, and specifically whether there's any gap between the old tariffs lapsing and new ones taking effect. That gap, if it exists, is where the near-term economic and market volatility is most likely to concentrate. And watch for legal challenges to the Section 301 approach itself. Given its track record surviving prior court challenges, most trade law experts consider it substantially more durable than the emergency powers approach. But more durable doesn't mean immune. And any early legal challenges will be worth watching closely for signs of how courts are treating this specific pivot. So here's my question for you. Do you think using a different legal tool to reach a similar tariff outcome is a legitimate constitutional workaround? Or does it undermine the whole point of the Supreme Court's ruling in the first place? Tell me where you land in the comments, and don't just agree with me. I want to see the disagreement in there too, because this is exactly the kind of question where thoughtful people land in genuinely different places. If this kind of breakdown, the part of the story that actually explains what happens next, not just the headline, is useful to you, subscribe to The Quiet Report. This is exactly the kind of slow-moving, undercovered story we specialize in tracking here. Before you go, there's one more piece of this I haven't mentioned yet. Buried in the same court, ruling is language that legal analysts say could affect a completely different set of executive powers, far beyond trade policy, powers that touch immigration enforcement, sanctions authority, and how future presidents of either party can act unilaterally during declared emergencies. I'm already pulling that thread apart for the next video, and honestly, it might end up being the more important story of the two. That one's coming next. Don't miss it. S.